Good evening, everyone. This is a bit like my dream superstar panel today, if you're a viewer of my show, because today we have one of Britain's foremost and most important newspaper columnists, one of Britain's most fascinating and powerful legal minds, and also a very, very important mother, grieving mother, who spent years making sure that the NHS was held to account for the death of her youngest son. And you would think in any normal Western democracy, right, that these people would be celebrated and would be a big part of who the government wanted to embrace, but not in the United Kingdom under Slippery Starmer, where all three, and also Graham Linehan, the writer of Father Ted, and the IT crowd who we're hoping to have today, and me to a certain extent, have all had our collars felt because of the fact that we challenge the narrative under this truly dystopian government. And so I would argue that free speech is dead in the United Kingdom. The fact that Alison Pearson is visited by police on Remembrance Sunday, the fact that Preston Byrne, one of our best lawyers, cannot return to the United Kingdom, cannot step foot in this country because he is so terrified of being arrested. And the fact that Lucy Connolly spent over a year in prison for a singular post on X that she deleted within hours on the day of the Southport massacre, a day where I'm sure you all agree we were all horrified and we were all feeling a depth of emotion that maybe was expressed in a bit of a different way. And I think we have to keep yelling about this because, unfortunately, all of our cases show why a lot of brilliant people are not speaking up. Because you're not paranoid not to speak up in the United Kingdom today. There is a realistic chance that you could end up in trouble with the authorities, losing your job, losing your livelihood, losing your business, losing your friends and family, or in the case of Lucy, losing your liberty. So we'll start off today. I think it's really important that our panellists just explain briefly what happened to them. Alison Pearson was, of course, the star columnist of the Daily Telegraph. Do you want to kick off?
Yeah, I'd just like to start by saying that I was here this time last year. Many of you will have been in the audience, and I was talking a speech about this woman who was in jail behind bars for a tweet, and thank God she's here with us today. Oh. Yeah, Lucy is the living exemplar of what we're talking about. Some people may know what happened to me. I was at home on Remembrance Sunday 2024, getting ready to go to our war memorial. Two coppers came to the front door and said they were coming about something I'd posted on Twitter a year earlier. I asked them what it was I'd said, and they said, "We're not allowed to tell you that, madam." And then I said, "Oh, well, could you at least tell me the name of my accuser?" And they said, "We're not allowed to tell you that either, madam, but it's not the accuser, it's the victim." So, centuries of innocent until proven guilty just doesn't apply. I was saying to Dan earlier that I've absolutely been steeped in this subject. I probably know far too much about it. But just to say very quickly what I now know, that since the Macpherson report 1999 found the Metropolitan Police guilty of institutional racism, and everything that's happened to all of us stems really from that moment. The police ceased to be an organisation that was interested in protecting ordinary people from criminals. More and more they've tended to be policing on behalf of what they call protected characteristics. So if you had a burglary and you could claim it was a racially motivated burglary, that would be great because they would pay more attention to that. So 2014, the non-crime hate incidents were introduced by the College of Policing, a sort of woke quango, and non-crime hate incidents never came before Parliament. They have no democratic legitimacy at all, but they are the basis now of thousands and thousands of people every year getting visits from the police for statements on social media. I certainly don't think I just complained about the police cuddling up to the Jew haters. How right I was, right, police cuddling up to Jew haters is a huge issue. So where we are, non-crime hate incidents like mine are supposedly receding, but don't trust them, ladies and gentlemen, because they're just now trying to introduce anti-Muslim hostility. And if someone like me says, I don't like women in our country wearing the burqa, because I think it's inimical to our traditions, it suppresses women, I'll be getting another visit from the police, won't I? But, I'm used to them. And as I said on that morning to the two police officers, I said, do you know what we're commemorating today? What we're commemorating today is tens of thousands of young men your age got on boats and went across the channel and in Spitfires, and they fought so we wouldn't live under tyranny. What would they think of you being here today? Thank you.
Very well put. Now, the reason that Preston joins us down the line today is because of a really terrifying case involving the British state censors. I've nicknamed them the off-communists. Preston, do you want to explain why you feel you can no longer step foot in your own country?
Well, it's not my own country. I'm actually eligible for British nationality, but I'm not taking it because nationality by descent. Not because I'm terrified of being arrested, but because it would be a tactical error. And I don't want to give any tactical errors because I want to punch these people as hard as I possibly can, and I want to do it. And the way you can do that is by ensuring that they can't punch back. So I'm a dual qualified English solicitor and U.S. attorney at law. I'm admitted in 2 countries, 3 states, and the District of Columbia as federal court. I currently am suing the UK Office of Communications on behalf of my client, 4chan Community Support LLC. In DC federal court. I've been working in the free speech space. I've been writing about it for 15 years, and I've been working in it as a practitioner for 8. I've been adverse to practically every single censorship authority on the planet. I'm presently adverse to Brazil, Ireland, the European Union, the UK, and Australia in live enforcement actions. I think I have more experience in this than any other lawyer living. When Ofcom decided to start going after American targets, I represented one of their initial 4 targets, and I wound up representing all of their 2025 targets. The only target I know of that I don't represent is X-Corp. And we decided these companies couldn't afford a defense, and very few lawyers were willing to represent them. So I assumed responsibility for taking on their case pro bono.
Wow.
Now, we've been very public about what our strategy has been the entire time, and the strategy really has been along 3 different axes. Axis 1 was, of course, to raise awareness about this issue in the United States and ensure that the federal government and state governments were aware of the issue so that they could respond accordingly. And we've seen diplomatic action from the Trump White House, including canceling a $40 billion trade deal with the UK over this issue. So I'd call that a win. Additionally, we decided to bring this case to court, so we sued Ofcom in the District of Columbia. The reason we did that was twofold. One, because we thought we had a way through sovereign immunity, and we've argued that in our opposition to their motion to dismiss. And 2, because we wanted to force them to claim sovereign immunity, because it puts the UK in a very uncomfortable position, where on the one hand they're asserting that they have sovereign power on American soil, and on the other hand they're asserting that they're immune from the jurisdiction of American courts. The third thing that we needed to do as part of this was to design a legislative counter-regime in order to shield American companies from this. We discovered over the course of our investigation and defense of these companies that no one had done it, so we did it ourselves. We called it the Granite Act, or the Guaranteeing Rights Against Novel International Tyranny and Extortion Act. That is a shield law which shields American companies from liability, which is an existing common law principle, but we want to put it in statute, and would allow American companies to sue foreign sovereigns in American courts as a result of any foreign censorship threat which is transmitted into the United States. One such bill was introduced in the state of Wyoming. It passed the Wyoming House of Representatives by an 80% supermajority the first time it hit the floor. We ran out of legislative time before we could get it done in the Senate. We will be back in 2027 when we expect we will be able to get that over the line in the Senate, and that would shield anyone speaking in or from Wyoming from these foreign orders and allow them to sue. Additionally, my base case for the Ofcom fight. Are we under the Chatham House rule here? Just query.
No.
No. All right. Well, fuck it.
To be frank.
my base case in terms of how this fight is going to end is that it is going to end in Ofcom's complete defeat, and the complete defeat will be the result of an act of Congress which is signed by the President of the United States.
Bring it on.
Yeah, bring it on. Yeah.
Bring it on.
That bill has not
But Preston, just to clarify, you were educated in the United Kingdom, right? St Andrews, yeah. So, someone who's very, very familiar with our law. Now, Lucy, as Alison says, this time last year, what was happening in your life?
Oh, me? What are we now? March. So April, March. I was in prison. Living my best life. No, I'm only joking. So if you don't already know, I was imprisoned for 31 months and served 12.4 of those in prison for writing a single, as Dan's already said, post on social media that was deleted within a couple of hours on the day of the Southport massacres. I was just having a conversation with somebody else, actually, and they found it quite surprising. So I was arrested on the 9th of August, 2024, and charged the same evening, and I didn't return home to my family until the 21st of August, 2025, for writing a tweet on social media. So make of that what you will. But, this is surreal now, sitting here in front of all these people. I didn't ever think that, almost people would be so bothered, if you like, about the fact that somebody had gone to prison for a tweet. But how wrong was I? Because, I get an amazing amount of support. And people are very upset about the fact that, free speech is dead and we are losing our liberties. And, is it the same for the grace of God go I? That it could be any one of us, under Starmer's regime that's being banged up for having an opinion. So, yeah.
And that is the key point, I think. Alison, we've seen it recently with Nick Timothy. Rather than people saying, oh, maybe I disagree with his call to ban Islamist displays of domination in public places, rather than say that, we see leading politicians say he should be expunged from public life. He should not have a role in politics at all. So it does feel like the left constantly does now lean into cancellation and uses attacks on free speech to do it.
Yeah, unless you're Peter Mandelson, in which anything
goes.
Any sins could be forgotten and overlooked. I think one reason I took up Lucy's case was Dan on his Outspoken show was interviewing Lucy's fantastic husband Ray, long suffering, I think we can say, and he keeps saying, "Don't get to say anything controversial." We're minutes away from being taken away. I like being among non-crime criminals. It's my favourite set now. But and
Ray is a Conservative councillor, which I think is important because that is why there was so much desperation to get Lucy.
We think that I think something that's important to make a point here is that. We heard earlier from Jack and from Layla talking about freedom. These crimes, quote unquote, or non-crimes, you can have one person report that they experienced hatred, right? And nobody has to ask that person if they have any motive against you. It seems to me absolutely extraordinary that the person who reported me and persisted, Graham isn't with us at the moment, but same thing happened to Graham Linehan, some very aggressive trans activist who relentlessly pursued him over frivolity, frankly. So that these people, it seems astonishing that, normally if there was a police inquiry, you'd expect at least the accuser to not be called the victim, but this is what's happened. But I think it's important to enlarge on what Lucy said, because when you and I were investigating Lucy's case, I was really shocked by many aspects of Lucy's case, but she was railroaded into a guilty plea and was an ideal candidate for bail, first-time offender, no flight risk, and was shockingly denied bail. Lucy will tell you some more of the details about that. But I subsequently found out, I suppose, when we know about Lucy's case, every day now there's some other trial or sentencing of someone on social media, in the judicial system, and someone says, yeah, but Lucy Connolly got 31 months, and this paedophile, has been given a suspended sentence. But just to make the point that the Islamist who attacked the Manchester synagogue was out on bail and had been charged with 2 rapes, right? He was on bail Jihad al-Shami was on bail, and Lucy, who had no serious charges against her, was denied. Why don't you say about about what happened with the bail, because it's fascinating. It was a stitch up.
Yes, so I was instantly remanded and told by the police that they wouldn't be giving me bail. They didn't really give me a reason why. They just said you won't be going home. And interestingly enough, the duty solicitor had already said to me when she called me, if they charge you, Lucy, they're not going to give you bail, which looking back is a really funny thing for her to say. How would she know at that time that they weren't going to give me bail? And that's exactly what happened. And I remember ringing Ray, crying, saying, Ray, they're not letting me home. And he said, what do you mean they're not letting you home? I said, they're keeping me here. And they put me in front of a judge so that was late Friday evening. Saturday morning, 10 o'clock, I appeared in front of a magistrate's court. Again, the solicitor came to represent me, and he said, I'll ask for bail, but you're not going to get it. You know. And lo and behold, he asked for bail. Absolutely not. Too dangerous. You might reoffend. And something that will never leave me, that judge I don't know his name, the judge in the magistrate court said that day, and the prosecution read it out like it was such a bad thing, and to this day I can't get my head around it. They said Lucy Connolly, also, one of the things she's also said on Twitter is she cannot understand why people are more upset than something she said on Twitter than 3 children being murdered. And they used that against me. They said that, they read that out. You're not having bail and you could reoffend because she said she doesn't understand why people are more upset by what she said than children dying. To this day,
And lots of your posts were things that polling shows the majority of Brits believe in. Lucy, you have now discovered, though, right, that your case did go to Lord Hermer,
Yeah.
Starmer's best friend, the Attorney General.
By 10 a.m. that morning. So going back to that morning, I've now got all the CPS files between and all the emails between the police and the CPS. So as soon as I was charged, there was this race on to get me signed off by the Attorney General so that they could prosecute me. Obviously, they couldn't possibly bail me and like normal people and wait for the attorney office to get back to them. They had to do it there and then. So yeah, I was refused bail again that morning, taken after that straight to Peterborough Prison, and told that I'd be reappearing in Crown Court because my case was too serious to hear in Magistrates Court. So I don't know how much you know, but the charge that I was charged on is an either-or case. It means it can be heard in Magistrates or it can be heard in Crown. But they decided I was public enemy number 1 and it must go to Crown Court. That in itself is very telling. A magistrate court can only give a sentence of up to 2 years and it's very often suspended. Crown starts from 2 years. So that kind of tells you a lot as well. So I, again, reappeared Crown Court Monday. Nothing really happened apart from my solicitor stitching me up. He was then said he'd put in a bail application, but he needed to be careful because we've only got one more shot. I'd had 2 bail attempts. I was on my last one. And if this one was turned down, there's nothing more that we can't do any more applications. So a couple of weeks went by and I finally got a bail hearing. That bail hearing lasted 2 minutes. So I don't know what my solicitor asked the judge or what they discussed in those 2 minutes other than my name, date of birth and address. And I've got the evidence of that on from the emails from the CPS. So again, I was turned down for bail. No reason given other than I might reoffend. That was the reason given.
Because everyone knew. I mean, that was the thing. Everyone knew at that time there was obviously this hysteria that had been created around social media posts, specifically in regards to Southport. So it was so clear to me very early on, when the rest of the mainstream media hadn't picked up on this, that you were a political prisoner. And we see these political decisions being made all the time. I mean, I don't know if people have seen this week, the Hope Not Hate activist, paedophile, staff member for Hope Not Hate, the left-wing activist organisation this week, who was found guilty of a sex offence against a 13-year-old girl is not going to spend a day in jail. Hugh Edwards did not spend a day in jail. So we see this all the time. But Preston, what is so worrying, I think, to people in the United Kingdom is that we hoped that cases like Lucy would actually wake the government up into realising that they can't keep going down this path. Yet, as Alison points out, they want to criminalise a conversation like the one that Nick Timothy has started in the country about mass Muslim shows of domination.
The point of why they wanted Lindsay to go through what she went through. The point of that was not for them to realize they've gone too far. They know for a lot of us they've gone too far. The point is the fear, right? The point is to make sure that everyone across the entire United Kingdom is afraid to speak their minds and afraid that something bad is going to happen to them. And I mean, that's part of what we're doing here in the United States, and why I won't set foot in the UK is because I need the freedom to demonstrate. So I posted a tweet that on Thursday when I was sitting in an airport lounge.
Yes, very good.
On my way back from Stockholm, because there was no way in hell I was flying through Heathrow. And that tweet was an email that we sent to Ofcom, and it featured a anime hamster in a Godzilla costume. And I hit send on that and then boarded my flight. And when I landed in New York 6 hours later, it had 1.2 million views on it, and Ofcom had been asked to comment on it by the BBC and declined to do so. The point of doing that is twofold. The first one is, if you read the papers in the case, it's a service of process joke that's 6 months old, because Ofcom sent us some documents, and we said, thanks, we're going to shred them and use them to line up my hamster's cage. So when they sent us an even bigger fine, we felt we needed to respond with an even larger hamster. But the other point is that I know that everyone in the UK is afraid as hell of Ofcom. Corporations are afraid of them. Lawyers are afraid of them. Law firms are afraid of them because they have to maintain relationships with the state, because the state is such a huge portion of their business, because the state's a partner in every single infrastructure project in the country and a lot of the building projects. My law practice does not suffer from that because I'm a solo practitioner in Connecticut representing the most hated websites in the world. And so as a consequence of that, it was important for us to demonstrate there are people in the world who are not afraid of the United Kingdom. I am not afraid of these people, and you shouldn't be either. And you shouldn't be, you have good reason to be, right, because of the legal system that you have. But in the ideal end state, when we're done beating these people, and that's exactly what we're going to do, you should be able to live your lives being able to send hamster memes to regulators without fearing that you're going to be arrested the second you touch down on British soil. You should be able to.
Yes.
Because the production of imminent lawless action, which it wasn't, then she should be allowed to speak her mind. Because that's how things work in the United States. That's how things worked in the UK for most of the last 40 years, until the last 20 or so when things have backslid. Really, you'd see these laws, the public order laws and the communications laws, used very sparingly. If you look, for example, to the case of Redmond Bate from 1999, where you had a Christian street preacher espousing notions of traditional Christian morality, convicted at first instance and then overturned on appeal. 10 years later, by 2010, every single case was going the other way. Right, every single case where someone was being offended or something like that, these overbroad laws existed now in a different cultural context. We're resulting in different outcomes. So, we're fighting from the United States to protect America's internet, and from my perspective, to protect Britain from these people and to demonstrate that resistance is possible. What comes next, of course, is we are expecting, I think everybody in this room, significant changes to happen in Parliament in the next 2 to 3 years. Namely, to be blunt, it's the Reform Party, right? Everyone thinks Reform's going to win the next election. I don't think Reform has a huge appetite right now to take on free speech as their cause, because I think that they expect that they're just going to sit on their hands and then coast to victory because Labour is going to shoot themselves in the foot. But what we need to be doing is we need to start planning for the future, right? We need to look at cases like Lucy's. We need to look at cases like Graham's, and we need to, architect a counter-regime, right, that will replace that. And so, we can talk about that in a bit, but we're going to be releasing, the Adam Smith Institute will be releasing a full model bill. I've been working on this project for 5 years for a UK Free Speech Act, the FSA. Our version of the FSA, I wrote the first one 5 years ago. It was 4 clauses long. We have a new version. It's currently going through final revisions. It's 28 sections long. It repeals 8 statutes in full, including the entire Public Order Act 1986 and the entire Public Order Act 2023. It's a very extensive and comprehensive bill, and we're going to be offering that to the world to consider. But we think at some point, right, we have to start translating this frustration with these rules and this censorship into political action. And that means bills, and that means parliamentary process, and that means getting MPs on board. And we're hoping that that process will start with our draft bill that we release in a week.
Yeah, because we definitely need something more muscular. And Alison, the thing that number one really worries me is that we're relying on Americans. That is pathetic. We are the home of free speech, or were the home of free speech, and it is pathetic that we are relying on Americans. But secondly, I think Preston's right to raise the politicians in this, because I don't think they quite understand. I mean, for example, we've seen the Conservative Party back in this country back the Australian government's censorship of YouTube by wanting to make it illegal for under 16s to access YouTube. Now, the thing is, that sounds like a positive thing, right? Trust me, it's not. Because if you work in the social media space like I do, YouTube is now the #1 broadcaster in the world. That censorship is being used in Australia to shut down creators. That's the point. So it sounds like a really soft, lovely thing. Are we going to protect under 16s from being able to go on YouTube? But that isn't actually what happens in practice. We need to be focusing on free speech, not going the other way and encouraging more censorship on the right, which unfortunately is what the Conservative Party have done.
Well, I'm not sure I agree with Preston, actually. I mean, I know Lucy and I had tremendous support. You had support from when Lucy was basically beaten up in jail. Richard Tice of Deputy Leader of Reform turned up almost within 24 hours, didn't he, to sit there and put his body between Lucy and the guards. So I think Richard is very concerned with free speech. I think Reform would plan to close the College of Policing, which is the woke heart of this, and I also personally, and I know Lucy as well, Kemi Badenoch has been a ferocious champion of free speech, and I'm bringing a legal action against the Police and Crime Commissioner of Essex, who's one of the alleged Conservatives, although showing no signs, of course, of knowing what being a Conservative means. And I was told by one of Kemi's aides that Kemi had rung up Mr. Roger Hurst, and the aide said, "You wouldn't have wanted to have been him." So I do think that actually that the two parties of the right do have pretty firm views on free speech, and I think we can certainly see a lot of the bills that are problematic. The Equalities Act, we need to get rid of this idea that police are policing according to protected characteristics. Every man, woman and child in the United Kingdom deserves exactly the same legal protection.
That Preston isn't convinced. I mean, Preston, I guess it's about making sure that there is legislation, right, to protect against this. So, for example, you could argue, why is Reform not arguing for the Ofcommunists to be abolished? I mean, I don't think Ofcom should exist at all, for example. Is that the type of thing that you're looking for?
Our bill, we're publishing a bill, right? And I think we'll have explanatory notes and everything that comes with it. I have a pretty good understanding of what free speech means and what foreign governments try to do to restrain that free speech. When you look at measures like, we're going to abolish the College of Policing, we're going to defend this case, we're going to defend that case, so we need to do a little tiny tweak by amending or abolishing just the Equality Act. I think that those proposed solutions underestimate the scale of the disaster that has occurred in the United Kingdom over the last 25 years, which I experienced. I moved to the UK in 2002, I left in 2017, and it has gotten worse since then. And it was getting worse progressively during my time there. So we are going to propose something, right? And our viewpoint is, I've been living inside this problem now for 15 years, and we are going to identify what we see as every single law on Britain's books that stands between the country and having something resembling the First Amendment. And we are then going to just put it out there, and then really it's up to politicians to decide, if you don't support this, why not? And if your base doesn't, so for example, there are things in there that Reform's not going to like. We abolish certain provisions, or we propose to abolish certain provisions of the terrorism acts that have been used to arrest Palestine Action protesters, the encouragement offense specifically, which allows the parliament to proscribe certain groups as illegal, and then thus make any speech in support of or encouraging support for that group also, right? So that's something which is not going to play well to the Tory base or to the Reform base, but it's something which, if the country wants something resembling the First Amendment, we have to go in and we have to tear up all the weeds in the garden. And all the weeds means all the weeds. And then we have to enact a statutory principle which says that anything that's been left behind has to be interpreted through a certain interpretive lens, which says that speech is essentially, if it's on the subject of morality, public policy, politics, or religion, is effectively by default legal, unless Parliament has specifically made it illegal, right? And so it'll be very clear what we've attempted to do, and we've tried not to bulldoze the British constitutional tradition when we did this. So, for example, we've made specific carve-outs to permit oaths of allegiance to the crown for public officers, which is a political statement and would be unconstitutional in the United States. But essentially, what we're going to do is we're going to offer a template, and we're saying, listen, from our perspective, the people who've been fighting this and working on this problem the longest, we think that this is our wish list, right? This is our laundry list of things that we think have gone wrong, and then it's going to be up to politicians to say, or firstly, political parties and grassroots members to look at that and assess: do we really want this? Right? Do we really want an environment which is this free? That's a question that only the British can answer for themselves. And then for the politicians, right, to have to answer, like, okay, you're going to leave this particular provision of the Public Order Act in, the one that was used to prosecute Lucy or someone else. You're going to leave this provision of the Communications Act 2003 in, which was used to prosecute Graham Linehan. Why? Right? Why do you do that? This lawyer over here, who's been fighting this for a decade and a half, thinks that that's a problem, and has offered this alternative. So from our point of view, it is, there's a fight to be had. I think the scope of reform that is needed, when we publish the bill, I certainly would hope that everyone downloads it and reads it in full. And when you see it, right, you'll see all the schedule of repeals and the things that we do and the restrictions we put on the state in engaging in political censorship. And every single thing that's in there is derived from a real world case, right? Something that happened in the real world, which required, we abolish Article 8 of the Strasbourg jurisprudence. Why? Because privacy jurisprudence has been used many, many times, time and again. If you look at the PJS case, which is, I can't mention it, famous singer, but I can't say who it is because I'm a solicitor of the senior courts and the super injunction's still live, right? That's something which is a restriction on speech. Contempt of court, the strict liability regime, which was used to throw Tommy Robinson in prison, that's been referenced here, right? So what we have, and is used to restrain public reporting. Section 5 of the Official Secrets Act, which can be used to restrict journalism on information that's entered the public domain through a leak from the government.
I'm loving this. It's dramatic and it's bold, and personally I think that's what's needed. But it's my third year at the
Thatch. Whether they like it or not, but we're going to publish the full Kahuna Bird.
Yeah.
We're going to have 10 days time.
Amazing. Well, we will be waiting.
It's up to you guys whether you want it.
We will be waiting. Yep, very popular in this room. This is my third year at the Thatcher Freedom Festival, and what I've discovered in my previous 2 years here is that by far the best questions come from the people in this room, and given we're coming to the end of the day, I think we want them to be spicy and outspoken and outrageous. So please, let's go.
Thank you all for your comments. I am a social conservative, and often at these events, and others who know me well will know what I'm going to say, there is a tension between libertarianism and conservatism, and I'm not going to call out who's who, etc. But lots of the remarks from our esteemed guests are making an eloquent case for libertarianism, and particularly all of those repeals. As much as I'm an advocate for free speech, I'm an educator, I work with young people, I work with young Muslim girls who have very different views to what I would have as a Christian, but I'm concerned that there is a libertarianism that's taking place and taking form. And so how do we temper liberalism with order, as good conservatives ought, in relation to free speech? How do we temper liberalism with order in relation to free speech?
Preston, that's probably one for you.
You don't. You either have free speech or you don't.
Yeah.
You're pissed off that your kid is looking at websites.
You agree, Lucy?
Yeah, it's not free speech if it's censored or only free speech if it's because you agree with it, or we either have free speech or we don't have free speech. There is no in between.
Oh, okay, we'll go there and then there.
Hi. Oh, hello. This is for Lucy. Until October last year, I was a magistrate for 7 years. Didn't act on your case, I must make clear to everybody here. I cannot believe, it's beyond credulity to me, that you were not granted bail. I've read all the details of your case. I've sat on hundreds of bail cases, and I just cannot understand how you weren't given bail. Furthermore, in terms of your case and the sentence that you received, being a good student of the sentencing guidelines, I cannot understand how you were given the sentence that you were given either. So it's very clear to me, although I don't like to say this or even think this, that you were a political prisoner. Simple as that.
Absolutely. Lucy, you believe you were a political prisoner, right?
Yeah, absolutely. People, it comes down to this. You can think what you will of what I said. You could think I'm the worst person in the world, or you could not care what I said. But the fact of the matter is, regardless of what you think of what I said, you should all want the judiciary to work as it should. You should all want it to be independent, and you should all want it not to be infiltrated by politicians and politics, and it's exactly what has happened. We talk about the sentencing guidelines. People don't believe me, and there are still many people that never will. They never use the word violence. I was not charged with violence, yet I was sentenced for inciting violence. Make that make sense? So all of a sudden, I'm being charged with something that I didn't plead guilty to. Regardless of whether I pled guilty, not guilty, I did plead guilty to one charge. That one charge doesn't use the word violence anywhere, yet I was sentenced to
basis.
Inciting violence. I to this day, I don't know why.
And I have got a quick question, because I don't want to be criticised for making a speech and not asking a question. So in terms of the magistrate part of it, is there anything that you can see that absolutely impacted you in terms of the magistrates court that sort of felt wrong? Is there anything now when you look back that you think, I don't know, somebody was nobbled or something like that?
Nobbles is not the word, but I think that my story had already been written. You know, they were told what to do, 100%, because you've worked in the court system, you've been a magistrate. You know that I would have, and ordinarily under any other circumstances, got bail. That it would have been a given. There's just no grounds to remand me. You watch these programmes, you know, real life, you know, police programmes, and you see the police on the phone begging the CPS to let them remand these people, and they're saying no. The grounds aren't strong enough. But yet, yeah.
Can I just a quick point? First of all, just want to pay very quick tribute to Toby Young and the Free Speech Union, who have helped absolutely. Huge source of comfort to those of us who find ourselves in this really frightening Kafkaesque situation. But just quickly coming back to that bail, the one person around the Southport massacres who refused to plead guilty was Jamie Michaels, a former Royal Marine in South Wales. Jamie was put, like Lucy, under huge pressure to plead guilty. He was absolutely bloody-minded. They kept him in a cell for 17 nights, and he said, "Well, I've been in Helmand Province, so they can't worry me. You can't worry me with this." And Jamie's amazing, very resolute. He got to Merthyr Tydfil Crown Court. This is why we cannot have this restricting the right to trial by jury. Jamie appeared before a jury of his peers. Merthyr Tydfil Crown Court, my part of the world. God bless those bloody people. 17 minutes to find him innocent. 17 minutes, right?
But under Calamity Lamy, though, there would be no jury.
Exactly.
There would be
and
no
Lucy,
jury
I
in his
believe,
case.
if Lucy Connolly had been before a jury, they would have found similarly and told them to get lost, basically.
Absolutely.
I wonder how much of this problem is cultural rather than just legal. If you look at the really outrageous cases, including yours, Lucy, and including Graham Linehan, they weren't brought under the Malicious Communications Act or the Equality Act. They were brought under the Public Order Act, which has been around since 1986. And until about 20 years ago, I think it would have been unthinkable that the Public Order Act would have been interpreted in that way. It was an incitement law such as almost every country has. An incitement was understood as meaning you had to actually incite somebody. You had to be, and there had to be a realistic chance that they would be incited and that they were acting on your words. I wonder whether what we're seeing is not the impact of years, decades of DEI training in the public sector generally and in the police specifically. And so even if we did everything that Preston is suggesting, which I completely agree with, of course we should get rid of all these terrible laws, brilliant initiative, and well done the Adam Smith Institute, are we still left with a problem as long as a large number of state employees believe that it is ipso facto wrong to cause offence to somebody with protected characteristics.
I do think there is a huge cultural problem, isn't there, Alison? And that is something that is bigger than the law.
I totally agree with you.
If I can chime in on
Yeah.
that, I mean, if you look at, there's a difference in wording between the Public Order Act, so I'm just going to pull up the exact language here. So, Public Order Act, 1986. So, we're going to pop open Section 5. So, if you look at the Public Order Act 1936, it says any person who in public place or public meeting uses threatening, abusive, or insulting words or behavior with intent to provoke a breach of the peace.
Change it to likely.
Right, so provoking a breach of
Okay.
peace
Oh, make
is
my point.
effectively equivalent to the U.S. fighting word statute, right? It's that you're saying something to somebody, and the logical, rational, immediate result is that there's going to be unlawful violence that occurs as a consequence. And then if you go over to 86, right, it's harassment, alarm, or distress. A person is guilty of an offense if he uses threatening or abusive, and it used to say insulting, and Section 4A still does, words or behavior or disorderly behavior or displays any writing within the hearing or sight of a person likely to be caused harassment, alarm, or distress thereby. So what they've done is they changed the standard because the Law Commission thought they were being clever and they thought the breach of the peace was some antiquated concept. So they just slapped in some new language that was completely meaningless. But a magistrate looking at the new language in the new cultural context that we have today looks at that and says, well, harassment, alarm, and distress, let's look at that in plain English. And then what happens is they make the determination in plain English. The determination is subject to an abuse of discretion standard, which is very difficult to appeal. And the question is, could a reasonable person have reached that decision? And if the answer is yes, then the conviction stands. So what you had is you had a changeover in the law, and then there was a change in public and cultural perception. So one thing our bill does is it abolishes the Public Order Act 1986 and then restores the previous offenses for affray, riot, unlawful assembly, and basically leaves breach of the peace untouched because that's still a common law offense. So what you had is you had some sloppy drafting in the 80s that was oh so exploitable, as we say on the internet, by litigants and by an over-aggressive state. And if you look back to the 1936 Act, which prevailed for 50 years before that, you see that there was a tighter standard. And then what happened was the standard was loose, it was loosened ever so slightly. And then you saw the logical consequence of that. So the difference is in fact architectural in the law itself and cultural, right? And so what we need to do is really get, and again, as I said, I've been living inside this problem for a decade and a half. So there's a lot of amendments that need to be made in order to restore the position because it's fundamental in the architecture of the laws that currently exist.
Interesting word there, restore. Yes, we got a question up here. Is that Eric? Hello, Eric. I'm so blind. Eric Kaufman.
Great. Yeah, I really enjoyed this. By the way, I was just going to follow up a bit with what Daniel just said and to say, well, is it enough just to have the law? The people are the policy. So sure, the problem, if you look at the U.S. case, for example, you had a conservative legal movement that fights to get conservatives onto the bench. In Britain or Canada, where I'm from, it's just drifted to the left. They self-select. So really, I don't think this is going to work just with some laws. You're going to have to start looking at appointments to the judiciary and the bureaucracy. If you look at Project 2025 and the impact on getting political appointees into the administration in the U.S., I think all of that is actually extremely important. So I just think lawfare is not going to do it on its own, or even changing laws.
Well, so what we have seen, though, and in fact, some of the key cases like Graham Linehan getting off a plane, 5 armed policemen arresting him, even people who would normally just roll their eyes realised this was terrible, right? And I think Lucy's case as well. So these keynote cases do matter. But I think the indoctrination of the police, I'm talking to various senior police officers who've come forward, and they think that if you do get a right-wing government that's serious about tackling this, the rank and file are not that wedded to going round to Lucy's house to arrest her. They really aren't. Scratch the surface. If you were to say, we're not having any more hate crimes, we are not having any more arrests based on protected characteristics, you are now going to be there to protect the public and to seek out bad people. And, you know, that I think we could have a cultural change, and you'd have to insist on it. I get that the judiciary and so on, but I think that the police initially being prepared to go out. The guys who came to my door, we've got some body cam footage of them before they knocked on the door, and one of them's trying to explain to the other one what it is, why are they there, and he says, yeah, it's sort of like hate crime, but not really. So they don't even know what it is. I mean, we can laugh, but it's not, of course, it's not funny when you're caught up embroiled in that. By the way, Dan, this is really interesting, and Preston might be interested in this. Mine was originally a non-crime hate incident, and when that wasn't going anywhere, it was escalated to an offence under the Public Order Act that I've been inciting racial hatred. And I've been told by several police officers that they use that as an off-ramp. They then kick it up to the Crown Prosecution Service, who will then say, Alison Pearson, insufficient evidence to prosecute. There was no evidence, Eric. No evidence at all. But what they do is they use that to look like you've been accused of a crime, and then they'll say insufficient evidence. So it's really sneaky and wrong.
Yeah, I mean, I super hope you're right about the police, but I keep seeing footage of the police. I'm sure lots of you guys have seen this too. Like last week, a guy being arrested at Manchester Airport for posting a joke on Facebook, and the police officer's saying to his wife, well, no, this may have been a really bad joke. Or Montgomery Toms, who's sort of a young freedom activist on a university campus, and the police saying to him, well, that sign, which I think said it's a mental illness to be trans, is really going to provoke people. So I'm not sure whether the police really believe in free speech, if I'm honest. I think we've got time for one more question.
We've accounted for that in our bill. And chiefly that if the way that the anti-censorship mandate is structured, if the state and any officer, agent, or agency thereof violates the right that we have set out, the victim of that, being the speaker, would be able to bring an action for injunctive, emergency, interim relief or damages and attorney's fees against any individual or the agency who did it, which is how it works over here, frankly. So
You'd be rich, Lucy.
it's really easy to get cultural change if you can put a financial incentive.
Yeah, indeed. Lucy, do you want to choose the last question? Because I can't.
Guy over here's the guy in the black jacket. You go.
Passing Acts of Parliament takes a bit of time. It's a very good idea. But I wonder if it would cut the Gordian knot a bit if, in this country, we have the doctrine of the operational independence of the police, which basically means they're unaccountable, which is fine for the last 200 years when they've behaved in a professional manner. But if we're going to get arbitrary policing and the invention of non-crime hate incidents at the level, below democratic accountability, maybe a short-term fix would be, for a period of 3 years or 5 years or something, to lift the operational independence of the police. So when they come knocking on someone's door about a tweet, the Home Secretary can sack them, sack the sergeant, sack the inspector, and sack the chief constable. It wouldn't take very much of that for the police to get the right idea.
Alison's keen on that.
I'm keen on that.
Okay, well, look, thank you so much. What an amazing panel, Preston Byrne. Everyone should support, I think, what he's doing. I'm not saying you have to agree with all of it, but certainly the concept is super important. I can't wait to see this document. Britain's #1 political prisoner, Lucy Connolly, who was in jail this time last year, and of course, Britain's #1 newspaper columnist, in my humble opinion, Alison Pearson. Thank you so much. Thank you.